Good afternoon and welcome everyone to this session of our conversation series, Racism and Law in Europe. My name is Liz Kulamadai, and together with my colleague Stefan Salomon, we are organizing this series in order to offer space to have discussions really about the role law plays in racism across Europe. So this series was triggered by the 2020 Black Lives Matter protests, which in our view opened up the space to have a conversation on racism, but also by the observation that whereas there was broader civil society engagement as well as policy debates on racism, it really didn't reach the legal discourse as much as we would have liked it to. So this is really the idea to think not only about racism, but really think about racism in relationship to law and showcase different modes of doing such reflections. This being said, I'll now hand it over to Stefan to introduce today's speaker.
So also from my side, welcome. And it's great to see so many people here. But before introduce the speaker, it would be great if, and we do that basically every session, if all of those of you who can and who are in a place that permits them to switch on the camera to please do so. It's nicer to speak to actual faces rather than into a black hole. So our speaker today is Thomas Spijkerboer. Thomas Spijkerboer is Professor of Migration Law at the Vrije University Amsterdam. And he has published widely across different fields and different issues of migration law. In particular about LGBTQI, asylum seekers and refugees. More recently, Thomas Spijkerboer has delved into the field of the relation, or into the relation between colonialism and international migration law. In particular, about what the exact relation between colonialism and international migration law is, and how migration law came into being in colonial structures and in colonial contexts. So this is basically what Thomas' lectures today is about. And before I delve into the first question, just a quick overview of the structure of how we of how this session will unfold. So this session is basically structured into two parts, and it really is thought as designed as a conversation with you. So in the first part, in the first 25 to 30 minutes, Liz and myself will have a conversation with Thomas and ask him 3 questions. This part will be recorded. The second part of this session will be a conversation with you, between Thomas and you, in which you can ask questions. This part will not be recorded. The reason is so that we all have a space, a safe space where you can ask questions. So on the relation between colonialism and international migration law. So in European human rights law, it is taken for granted that states have the right to control the admission of non-nationals. And Thomas, you have argued in your writings that this means that when it comes to migration law, the starting point of courts and of states is the state, not the rights of the individual. Could you explain what you exactly mean by that?
Sure. First of all, thanks a lot for the invitation. It's an honor to speak in this series, and I think it's a much needed series, a much needed conversation to have about race and law, which is usually, if it's seen as a topic at all, it's considered as, oh yeah, that's about law against racial discrimination. Well, in fact, it goes much further than that. As to your question, yeah, if you think of the normal way that human rights are applied, then if you think of, for example, the right to liberty, if the police comes and arrests you, then it may be that the police has a very good reason to do so. You may be arrested for good reasons because you were just going to kill a fellow human being. However, regardless of that situation, the structure of argumentation in human rights law is that you have a right not to be arrested, you have a right to liberty. The state may infringe on that right, may limit that right, but the state always has to justify why it limits that right. So the state can only arrest me if they have a case, if they can make plausible that I'm going to do something terrible or that I'm wanted for a crime or something. So the state has to justify interference with my right. The only, and literally the only exception to that is migration. So when a Dutch person wants to have a relationship with, let's say, a Nigerian person, and the Nigerian person, for that reason, wants to come to the Netherlands, then the Dutch authorities, in principle, have a right to say no, and they don't have to explain exactly why. And only if the Nigerian person and the Dutch person together can convince the Dutch authorities that, first of all, they have a relationship being that can be taken seriously, that's entitled to protection by the law, and if there's no other place on the globe where they can have this relationship, then there may be an obligation for the Dutch authorities to allow the entry of the Nigerian partner. So here it is the individual who has to justify why he or she wants to use a right. Why there's an entitlement to private and family life, and not the state that has to justify why, what the problem the state has with this particular individual. This has been called the Strasbourg Reversal, so it's human rights upside down. It has been termed the Strasbourg Reversal by Marie-Bénédicte Tambour. Bas Schotel of the UvA has also worked on the issue, and of course Tendai Chuma, who wrote this rightly famous article on migration as decolonization, has pointed to the inversion. So it's not something I discovered, but in my work I do point out. I begin by pointing out that only in migration law you see this human rights upside down, where the state has a right and not an individual, and where the individual has to justify why, so to speak, the individual has a right to interfere with the right of the state, instead of the normal construction of human rights where the state has to justify interference.
Thomas, if I may jump in there, where does this right come from? So where does the right of states to control the entry of non-nationals to their territory come from?
This is a question that has been asked for a long time, and funnily enough, I think the origins of migration in international law coincide with the origins of international law as such. So one of the first authors on international law came out of the colonial encounter. That's the analysis of Tony Engie in his book, and you see the founding fathers, they were all men of the field, that they all address migration. They all address the rights of individuals to move across the earth. Now, the interesting thing is that this is a very long story, and I'll try to make it very short, is that during intense phases of colonial expansion, you see European authors emphasizing the right to migration. So there is, in the 16th and early 17th century, Francisco de Vitoria, a Spanish academic who is famous for legitimizing in an extremely sophisticated way the colonization of the Americas. He addresses the right to migrate, and it's one of his justifications for Spanish colonization. He says the right to travel to the Americas and to engage in trade with the Indians And when they refused to admission to Spanish travelers, that was an act of aggression against Spain, and Spain could defend itself. This is literally how he argues it. Yeah, so it seem a bit far-fetched, but he says it was a form of defense against aggression from the side of the Indians, to then go to war against the Indians in order to enforce the right to travel and to communicate and to trade with the Indians. Hugo de Groot has a different construction, but it's still, he emphasizes the right to travel of the Dutch to the East Indies. And at the end of the 19th century, someone whom I discovered thanks to Stefan Salomon, there's Mr. Blunchley. Blunchley is a Swiss international law academic working in Germany, who places on Earth where there is still this idea that you can close yourself for rights in 1872 or something. The good news is that this is on the retreat, because both China and Japan have now accepted by treaty to open up to foreign trade. And the two treaties he mentions are phenomenal treaties. The first is the 1842 Nanking Treaty, which is the prototypical so-called unequal treaty, which China was forced to accept because Britain had won the war, and the treaty itself says so. Like, Britain has won the war, so this is the deal. So that's the first treaty he mentions, the Nanking Treaty, an infamous treaty, and the other is the US-Japan treaty that gave the name to the term. I only know the Dutch version, kanonneer boat diplomatie, so something like torpedo boat diplomacy progress. This is incredible progress of Weltrecht, of global law. So finally, we are enforcing, Europe is enforcing its civilized norm of free movement on Asia, and we will do the same in Africa as well. So that was the idea up until the 19th century. States did have a right to limit migration, but only if they had very good reasons to do so. So in the legal argumentation of these early modern and modern authors, you see the structure you would expect. A state can limit freedom, but it has to justify it. However, then something happened. Starting in the mid-19th century, the abolition of slavery led to a labor shortage in colonies, British colonies, Dutch colonies, I guess also French colonies, but there I don't know the story, and on the west coast of the US, because the US was colonizing, was exploring the west coast, and one of the ideas was to use slaves for that. But since emancipation and since the opposition of the northern states against the use of enslaved persons, that was not feasible. So on the west coast of the US, there were programs to let's say import Chinese and to some extent Japanese laborers. Britain used people from India, and the Netherlands also used people from British India. And when the Brits ended that, they used people from Java they moved them to the West Indies, the Dutch West Indies. So you see movement of racialized persons. Up until then, the international law had justified the movement of Europeans to colonies. The same ideology, the American West Coast and other colonies. However, there, I will limit myself to California, because then I have to tell only one story. But the story in other places is very similar. There was concern in California about the white majority. Like, it should be a white country, it should be a white settler society, not a Chinese, not an Asian settler society. Authorities wanted of different local authorities and local authorities and federal authorities. In the end, the US passed the Chinese Chinese Exclusion Acts. It was not now, that was what it was called, Chinese, period. That led to litigation, and in 1889, the US Supreme Court ruled that as a function, as a self-evident part of its sovereignty, every state has the right to exclude foreigners of a different of a country because they are not willing to assimilate. The US Supreme Court, in an abrupt turnabout, is completely unaware, pretends to be completely unaware of a right of persons to mobility, to move, to migration, and even completely denies it. So it says, no, states have a right to exclude, period. And they don't have to justify it. It's excluding Australia and New Zealand. The United Kingdom and France and the Netherlands had introduced free movements in their colonial and post-colonial empires after the Second World War. And when they started to end this, the UK in 1962 and later France in 73 and the Netherlands in 1980, there was litigation, and in that context, the Strasbourg court adopted the Chinese exclusion law doctrine, so to speak. So it's a long story, but until a bit more than a century ago, the opposite was obvious than what is now obvious in Strasbourg in Europe in human rights law.
That's such an interesting kind of like history, and it kind of like shows that movement, kind of like how international law was involved with movement of people from European countries to the colonies. And so the question I would be interested in, kind of like, you've shown how international law kind of like was involved and facilitated the movement of people, of Europeans to the colonies. But how is this colonial history of immigration law kind of like reflected in today's EU law or European law? And how, since the series is about kind of like racism, and how is race kind of like inscribed into that? Which role does race play in this?
I think that the major way in which colonial history works in present day European law is through the Strasbourg Reversal, is through the, let's say, in Europe, in the global north, universally accepted right of states to exclude, unless an individual can trump that right through through a human right. Oh, that is the major way. I think you can see this in lots of technicalities, and as I said during the conversation we had before the waiting room was open, so before the audience joined, I tend to get carried away, because I think that if you are aware of this history, then a lot of case law of the past that has been given by the two European courts since 2014 suddenly falls into place, because everyone has noticed that there is a change in the case law of these courts, and that it's quite remarkably pro-state sovereignty. So it used to be more subtle, it used to be more liberal, it used to be more interested in, it used to attach greater importance to individual rights, including rights that might lead to migration, that might give migrants rights. Since 2014, since the Glijvia judgment of the Strasbourg court, there has been a marked change. Everybody has seen it, and I think that you can understand the change, and also you can understand that the change, in fact, is a pretty small one. If you situate this case law in this centuries-long story, because under colonialism, lawyers, colonial law had three strategies, let's say strategies, to ensure that in a colony the colonizers would not be subject to the same law as the colonized population. And so in the Dutch East Indies, there was the Dutch East Indies was a great example of what we would now call legal pluralism. And the fathers of Dutch legal anthropology were working in the Dutch East Indies because they had to decide which populations were there. There were roughly three. There were the natives, the Europeans, and the Asians who were not natives. So the Asians who were more civilized, than the native population of Indonesia, like the Japanese and the Chinese. So they had three legal systems. And they applied three legal systems to these people. And of course, when people married across the color line, there was a problem. You had to assign the family to one legal system. So it was a lot of trouble. But they designed ways of doing it. I think you can see that, and I will flag the three strategies without giving examples, because then I will get carried away and it will take for too long. The first is that you may say, well, this law applies in the metropole, but not in the colony. You see that in Article 56 of the European Convention on Human Rights. That's the so-called colonial clause that says if a country, if a state becomes a party to the European Convention of Human Rights, it can indicate whether or not it will apply the European Convention on Human Rights to the territories for which international relations it is responsible. And that is a kind of chic way of saying to its colonies. So it can decide whether or not it can do so. Article 355 of the Treaty on the Functioning of the EU provides, gives this colonial structure for European law. So European law can apply to some islands, but not to other islands. And then if it applies, you apply. So that is one logic. Law doesn't apply. The second is, if you apply it with, and that's terminology of Article 56 of the European Convention on Human Rights, you apply it with due regard to local requirements. Because of course, in the colonies, we may have to be a bit more brutal than we are in the metropole. Yeah? Because we are faced with a very problematic that way of thinking. For both, I think you can see that, of course, the two courts, the Strasbourg and the Luxembourg court, do not apply these provisions, but they apply the logic. In some cases, they simply say, well, the European Convention on Human Rights or EU law doesn't apply to this population of formerly colonized persons. So I see migrants as I analyze in this context migrants as formerly colonized people who now come to the metropole without having asked for permission before. So they are colonial populations moving to the metropole. Now, the first strategy is law doesn't apply. The second is, yes, we do apply law, but with due regard to local circumstances, we lower the standards. You see examples of that, of both in case law of the two courts. And the third is the use of emergency powers. Now, for emergency and such, many people think of Giorgio Agamben. I think that's problematic because he ignores that the notion of emergency is in origin a colonial governance technique. This has been described by Nasser Hussain and John Reynolds in their books. And I think what we see now is that formerly colonized populations, when they move to the metropole or try to move to the metropole, then European legal systems find it completely obvious and normal to use the notion of emergency against them, to lower standards or to decide not to apply standards. So I think this is how you can see that this history, this long history of migration law being part of and being completely linked with colonialism and with the developments of colonialism and with the stages of colonialism. I think you still see that now. So essentially, I'm saying that my analysis is if you as soon as you are aware that migrants and refugees are, roughly speaking, formerly colonized people coming to the metropole without the metropole's permission, then you see that the metropole applies classical colonial legal governance to these populations, not in the technical sense of the word, but that is the logic. Judges find this so logical, legislators find this so logical, because of course we cannot apply our Rolls-Royce version of law to these racialized hoi polloi. Yeah, that's not what it was meant for, and that goes against the logic of the European legal system.